And let's take you next to Constitution Hill in Johannesburg. This is where the APEC court is continuing to hear arguments in the case against local and international banks who are all accused of colluding to manipulate the rand-US dollar exchange rate. The Competition Commission now challenging a ruling by the Competition Appeal Court, which had cleared 13 financial institutions. Zoleka Qodashe is live now with more details from the Constitutional Court. Good morning, Zoleka. And again, as we said, this is a massive showdown. It's a marquee case that also allows the Competition Commission to expand its scope of jurisdiction and have more teeth when it comes to going after companies who are guilty or accused of errant behavior.
That's correct, Iman. Good morning. It has been marathon hearings before the Constitutional Court. Yesterday, we heard from several banks that sought to advance their arguments before the justices of the Apex Court. Now, there are a number of grounds upon which the respondents seek to have the Constitutional Court dismiss the application for leave to appeal by the Competition Commission. Now, you'll remember that this is in relation to the allegations by the Competition Commission of colluding between these major banks in the rand-dollar exchange rate. And so the banks yesterday had their say before the Apex Court, accusing the bank of, the commission rather, of procedural and substantive failures in their approaches. We understand from the position of Standard Bank, according to the arguments that we heard yesterday, that the commission failed to actually engage with the bank in relation to the allegations against it around 2017. Now, they also raise a number of issues in relation to the re-litigation of the matter. Now, the banks accuse the Commission of trying to re-litigate the matter in violation of that legal principle, res judicata. Now, what res judicata seeks to do is to prevent parties and litigants from re-litigating a matter that has already reached finality in a different court, and where parties seek to advance the same merits and the same parties in a different court. And so because that matter has reached finality before the Competition Appeal Court, the respondents rather, argue that it cannot be re-litigated before this court. You'll remember, Iman, that this process is governed by the Competition Act. And what the Act does is that it prescribes a manner in which disputes have to be handled in relation to cases such as this. Now, the matter starts with the Competition Commission. It then goes to the Competition Tribunal that will receive the matter after it is referred to it. And then, if there is still a dispute, it goes to the Competition Appeal Court. And that is where the banks were successful against the Commission. And so the legal counsel for some of the respondents yesterday saying that the matter cannot be re-litigated before the Constitutional Court. We heard from Advocate Chris Loxton, senior counsel, who represented one of the banks and had this to say. Let's just take a listen to what he had to say in relation to res judicata.
No, Justice Matopo. And the reason for it with respect is the following. The elements of res judicata would be a final judgment of a court with jurisdiction, not subject to appeal. Once those requirements are met, then res judicata applies, and it doesn't matter what the parties do. They may, for example, erroneously believe that it wasn't a final order, but it's still a final order, and it's still res judicata.
Now, Chris Loxton was responding to a question by Justice Matobo of the Constitutional Court in relation to res judicata. Today we're expecting Advocate Tembeka Ncukaitobi, Senior Counsel, to respond to this on res judicata as well as the issue of jurisdiction when he gives his response to the banks today. And then, of course, Newzroom Afrika will be giving viewers that rebuttal by the Commission as proceedings kick off at 10 a.m. Iman.